In this video, we are going to focus on co-ownership. I put trust here because these two topics are closely related to each other. If you want to know more about trust, you can watch my later video. So, what is co-ownership? Co-ownership means that there is more than one person owning a property together. Let's say we have A and B and they own this property together. Then we'll say A and B are co-owners. Where there is only one owner, there is sole ownership, and that one person is the sole owner. There are two types of co-ownership. The first one is joint tenancy. Let's have A and B again. One feature of joint tenancy is the four unities. The first one is unity of possession. This means that A and B possess the property together. We also have unity of interest. This means that every act in relation to the property requires the collective agreement of all joint tenants. Let's say A and B are husband and wife and they would like to leave the property to their son. They want to make a will. This requires the agreement of both A and B. It doesn't work if only A agrees to it but B does not. However, there's an exception, and that is termination of periodic tenancy. And the case is Hammer-Smith. This means that if A and B let the property to somebody else on a periodic tenancy basis, A can terminate the tenancy without obtaining the agreement of B. So, this is it about unity of interest. We also have unity of title. This means that both A and B have title to the property. And finally, unity of time. This means that A and B have interest in the property starting from the same time and during the same period. Other than four unities, joint tenants also have the right of survivorship against one another. This means that if B passes away, his share will be given to A, and A will become the sole owner of the property. So the right of survivorship means that the one who survives has the right to get the share of those who pass away. So this is it about joint tenancy. Now you may say, joint tenancy is so troublesome. You need the agreement of all joint tenants before you can act on the property. What if there is disagreement? So you may be thinking of severance. We have to look at Section 8 of CPO, that is the Conveyance and Property Ordinance. We have to look at Section 8 subsection 1, which tells us how we can sever a joint tenancy at law. So we need notice served by a joint tenant on other joint tenants, or an instrument. For the meaning of instrument, you can look at Section 2. For notice, this means that if a unilateral notice had been served by a joint tenant on other joint tenants, then the joint tenancy will be severed at law. What about the possession inequity? We can look at Section 8 subsection 2. It tells us that we will need notice served by a joint tenant on other joint tenants. Note, this is the same as what we just said about severance at law here. So the combined effect of both provisions is that a unilateral notice has two effects. First, it can sever a joint tenancy at law. Second, it can sever a joint tenancy in equity. So bear in mind there are two effects of a unilateral notice. And other than notice, to sever a joint tenancy in equity, we can make use of any other method that would, but for subsection 1, be effective at law. This means that if a joint tenant fails to sever a joint tenancy at law for any reason, for example, he or she fails to satisfy the requirement of an instrument, then this provision tells us that even though the joint tenancy cannot be severed at law, it will be severed in equity. So this is what this part is about. Let's look at the previous part. Any other method that is effective in equity. So what are these methods? We have to look at case law. And the relevant case is Williams' Enhancement. It tells us that there are three ways in which we can use to sever a joint tenancy in equity. The first one is acts which operate upon a joint tenant's share. This means any act that would alienate a joint tenant's share. When the four unities are destroyed, then there wouldn't be a joint tenancy. An example I can think of is a charging order. Note, whether or not a charging order will sever a joint tenancy is still in dispute, but some suggest that it would, and their argument goes this way. Let's say we have A and B. So a charging order is in fact a way for you to charge your property when you're borrowing money from somebody. So let's say A wants to borrow money from a creditor. A creditor is somebody you borrow money from, and A charges his interest in the property when he borrows money from this creditor. But unfortunately, A enters bankruptcy, and this creditor wants his money. So what can this creditor do? this creditor can enforce the charging order. And now you may say, what about B? B is completely innocent. It doesn't seem to make sense that B should be affected by what happens to A. So if the effect of the charging order is to separate the joint tenancy, then A and B will become tenancy in common. And tenancy in common is the second type of co-ownership, which we will look into later. Now, as I've just said, whether or not a charging order can separate joint tenancy is still in dispute. If you want to know more about this area, you can look at this case. Now, we also have other ways of severing a joint tenancy in equity. There are mutual agreement, but not in writing. So it can be an oral agreement, and by a mutual course of dealing. So we have to look at the conduct of the parties. So this is it about severance of joint tenancy. And let's look into the second type of co-ownership, that is tenancy in common. Tenancy in common differs from joint tenancy in two ways. First, there is no right of survivorship. And secondly, there are no four unities. There is only unity of possession. So we have A and B. A and B possess this property together, but their shares are clearly defined, let's say 50-50. So if A wants to transfer 25% of his shares to somebody else, that is totally fine. Even though A does not obtain the agreement of B, A can do so. And the result will be it will retain 25% of the shares. That's why I say tenants in common can freely dispose of their own shares. So now we know the differences between tenancy in common and joint tenancy. How can we distinguish them in practice? There are several ways to do so. First of all, we ask what is the express intention of the parties. We have to look at the deed. If the deed says that this is a joint tenancy, then it is a joint tenancy. Even if the deed does not say it clearly, we can look at the terms. If the terms suggest that there are four unities, then this is probably a joint tenancy. And even if there isn't any clue on the deed, we can resort to Section 9 of CPO. That section says that there is a presumption of tenancy in common. However, note that this presumption only applies after the commencement of CPO. So for cases before CPO, other rules apply. Now we know how to distinguish between the two types of co-ownership. Let's talk about the relationship between co-ownership and trust. When we come to trust, we will know that when we talk about ownership, we have to look at two positions. The first one is the legal position, and the second one is the equitable position. We always start with the legal position. Let's say we have a legal tenants in common, and the rule says that equity follows the law. This is laid out in the case of Stat and Delta, which is a very important case, and we will definitely return to it when we talk about trust. According to this rule, when we have legal tenancy in common, then in equity, we will also have equitable tenancy in common. But then, this rule may not apply when it comes to legal joint tenancy. Equity may not follow the law. There may be discrepancies between the two positions. An example when this discrepancy will happen is when purchase money is provided in unequal shares. So let's say we have A and B who are joint tenancy. At the time of acquisition, A contributed 90%, but B only contributed 10%. Now, A can argue inequity by resorting to principles like resulting trust and common intention constructed trust, which we will talk more about when we come to the trust video. If A successfully convinces the court of either of these equitable principles, the result is that A will get 90% of the beneficial interest in the property because A contributed 90%, and B will get only 10%. So there are clearly defined shares, so A and B will become equitable tenants in common. And note, there is a discrepancy between the two positions because at law, A and B are joint tenants, but then in equity, they are equitable tenancy in common. So you can see how this works. There are also examples when the discrepancy occurs. Another example is loan or mortgage. So this simply means that equity presumes joint mortgagees, say banks, to be beneficial tenants in common, and partnership assets as in the context of company law. So business partners may be presumed to hold assets as tenants in common. So this is it about co-ownership. Thanks for watching.